Recently, I read a discussion among experienced civil rights attorneys debating whether one officer reasonably relied on information provided by another officer. The conversation was exactly what you would expect. What was communicated? What did each officer know? Was probable cause present? Was reliance reasonable? Those are the questions that the law requires. But as I read the discussion, another question kept coming to mind. Before it's asked whether an officer reasonably relied on another officer's information, how did the police department expect officers to evaluate information received from one another? That's a different question. Notice what I'm not saying. I'm not saying the answer determines probable cause. I'm not saying it establishes municipal liability. I'm not saying every false arrest case becomes a failure to train case. I'm saying it's a different layer of analysis. Because police departments don't simply expect officers to enforce the law. They expect officers to make decisions every day with incomplete information, with conflicting accounts, with evolving facts, with another officer's observations, with dispatch information, witness statements. Those are recurring decision points in policing. Not rare events, routine ones. So here's the question that interests me. How does a police department prepare officers for those recurring constitutional decision points? Not for one specific incident, not for one lawsuit, as part of preparing officers for the realities of police work. That question doesn't replace legal analysis. It exists alongside it. Attorneys will continue asking whether an officer's decision satisfied the Constitution. Judges will continue applying the law to the facts before them. That's exactly how the system should work. My role is different. I'm interested in understanding how a police department prepares officers for the kind of constitutional decisions they are expected to make long before litigation ever begins. Preparation isn't simply about delivering a class. It's about helping officers recognize the moments where constitutional judgment matters most. The moment when information is incomplete. The moment when another officer provides information. The moment when a supervisor isn't immediately available. The moment when the next decision may affect someone's constitutional rights. Those moments happen every day. If a complaint later alleges that a police department failed to prepare its officers, I believe those recurring decision points deserve thoughtful examination. Not because they answer every case, they won't. Not because they replace the legal standards, because they don't. But because they help explain what the police department was preparing officers to do before the incident ever occurred. That's the lane where police praxis operates. Not deciding whether the Constitution was violated, not deciding whether liability exists, but examining how a police department prepared its officers for the reoccurring constitutional decisions that define modern policing. To me, that's a conversation worth having, because constitutional policing doesn't begin when a lawsuit is filed. It doesn't begin when a deposition is taken. It begins much earlier. It begins with how a police department prepares its officers for the responsibilities they will eventually carry on the street. That's the question that continues to guide my work. I'm Tom Loglisci. Thank you for listening to Police Praxis Audio Briefings.